Welcome, ladies and gentlemen, and good afternoon. It's time to begin with our Board of Zoning Appeals regularly scheduled meeting for January the 4th, 2018. My name is John Michael. I work with the Metro Codes Department, and I'll be presenting the cases to the board for their review in today's public hearings. Here at the beginning of the meeting, we would respectfully ask, would you turn off your smartphones, iPads, or other tablets, just to make sure that there's no interruption of the board's proceedings, as each presenter does have a limited time. Thank you in advance for your consideration. For today's public hearings, the board reviews the correspondence that's been submitted both in support of or opposition to the meeting. The board also reviews correspondence and recommendations from other government agencies and even elected officials in some cases in preparation for the hearings. So today the staff will review the site plans that are presented by the staff member, or rather the board will review the site plans, maps, photographs, and other documents that comprise the case record for each of these cases. At the conclusion of the staff's presentation, the appellant will present his or her case to the board. After the appellant's presentation, those who wish to speak in support of an appeal will have the opportunity to do so. If the appeal has opposition, those opponents would have the opportunity to come up and speak next. After the opposition presents his or her testimony, an appellant would have a period for rebuttal. It's important to note, out of the originally allotted amount of time, appellant should save some back for rebuttal if they wish to do so. Under our BZA rules, an appellant has 10 minutes for presentation if there is no opposition present. For contested cases, BZA rules allow 15 minutes for each side to make the desired testimony. Should the appellant wish to provide rebuttal testimony, as noted, the appellant should save that out of the originally allocated 15 minutes. For the benefit of those who may be in a group wishing to speak in opposition to a case or in support of a case, that's a shared 15 minutes. Not everybody gets 15 minutes to bite at that apple all day long. So divvy up your time accordingly in advance. At the conclusion of each hearing, the board will deliberate and then vote on the case. The board's vested with the power to do so under the provisions of the Metro Zoning Code, namely section 17.40.180. All of the section numbers to which we refer today come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council, took effect on January the 1st, 1998. I'll introduce the entire Zoning Code and make it part of today's record for each of our cases. The Metro Code requires a record of these proceedings, and because the BZA meetings are recorded for Metro Channel 3, it's imperative that anyone wishing to address the board come forward, take a seat here at the front table, and use the microphone. And introduce yourself by name and address, and then make the desired presentation. The Metro Code requires 4 of our 7 board members in order to establish quorum. The Code also requires at least 4 affirmative votes in order to grant an appeal. In the event that only 4 members are present and an appeal fails to receive 4 affirmative votes, the appeal will be re-advertised for the next public hearing. In the event that 5 or more members are present and the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Any application that fails to obtain 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal a board decision to the Chancery Court within 60 days of the hearing date. Additionally, an aggrieved party may file a motion for rehearing within 60 days of the original hearing date, pursuant to the terms of the BZA rules and regulations. After that time elapses, the board decision becomes final, and no further action can be taken. For the appellants, if your appeal is granted, you are in fact required to obtain the permit for which you applied. A permit must be obtained within 2 years in order for a BZA approval to remain valid. After such time, you would have to start the permit application and subsequent BZA appeal process all over again. It should be noted that if any false or misleading testimony is presented to the board's approval could be revoked at a later date by means of a show cause hearing before the BZA. And with that, Mr. Chairman, I submit that all the cases have been filed in the proper order, all appellants have been notified by certified mail, and all legal notice requirements have in fact been fulfilled. A couple of preliminary announcements, Mr. Chairman. First, with regard to case 2017-349, property located at 122 Liberty Lane. That case has been withdrawn by the appellant as their revised plan will now meet the zoning code requirements. And secondly, case 2017-397 involving the property at 4500 Harding Pike has been deferred to a later date. The district council member was out of town on family business today and unable to be here, requested the deferral, and the appellants agreed to defer to February the 1st. Again, that's case 397 for the property at 4500 Harding Pike, deferred to February the 1st.
So neither one of those cases will be heard today?
Neither will be heard. If for any reason anyone in our audience is here for one of those two cases, they will not be heard today, and while you're welcome to stay, you will not be hearing the case you perhaps came to hear.
Okay. Before we get started, I know we had the amendment to our BZA rules. Can we kind of just briefly discuss these at the top of the meeting?
We can, and in fact, if you'll forgive me, I don't have that document in front of me at the moment. Perhaps after I blow through the remainder of the announcements, we can go to that. Thank you. I think there were 5 general concepts raised for members of our audience who may not have this document. There are 5 concepts suggested to the board for their consideration for revisions to the BZA rules and regulations. The first has to do with Rule 8 out of that body of rules, a reduction of the time limits for presentations by both appellants and opponents. Presently on contested cases, both sides have 15 shared minutes to make their desired presentations. The suggestion is to reduce that number to 10. Additionally, on uncontested cases, there are 10 minutes available to the appellants, and the suggestion is to reduce that to 5. I would note to the board always has the ability, upon its own motion, to extend such times, and there is no suggestion at this time to change the practice of stopping that time from running during a period of board questioning.
Right. As you know, the BZA agenda has gotten much more lengthy than it was when we initially adopted the rules. How many cases roughly did we have last year?
I think it was 1 million, Mr. Chairman. That's the city's rough estimate. Sorry. It was approaching 450, which is an increase of roughly a little over threefold from what we did even 2 years ago.
Right. And so I think, and it's rare that we have a case where someone bumps into their allotted time, especially since when we ask questions, it doesn't count against them. So any discussion or thoughts about this particular?
No, I think it's fine. I mean, I've been on this board 6 years. We've never cut off anyone offering substantive information ever.
Yeah, and I think the other thing is, John Michael said, if it's a hotly contested case, a lot of people want to speak, we could always, say, okay, 15 on each side or whatever we want. So next one, John Michael.
The second suggestion made to the board with regard to these rules is involving Rule 3A, has to do with BZA appeal filing deadlines. As you know, Mr. Chairman, we try as hard as possible to get folks in a timely manner when they're up against those filing deadlines so they can get in front of this board as expeditiously as possible. However, that rush often leads to people squealing in on 2 wheels at 3:59 p.m. before our office closes and employees depart, thinking that they have, quote unquote, met the deadline. We invite this clarity instead. Appellants must meet with one of the zoning examiners at Metro Codes in order to file a BZA appeal. Merely delivering documents will not constitute the proper filing of an appeal. Appellants must be signed in to see a zoning examiner before 12 p.m. Central Standard Time on the date of the filing deadline. Those who sign in at 12:01 p.m. or later will miss the filing deadline and thus be placed on a later docket.
Now, board members, this affects more of our hardworking staff and managing the amount of people and traffic and permits that come into the office. So does anyone have any comments on this? Okay, I think we're all in agreement. That's a good rule too.
The third suggested rule change involves Rule 2 merely changing the title of Rule 12 from minutes and records to records, as our board does not in fact utilize formal minutes in the manner that, say, the Planning Commission does. The fourth is from Rule 9, a subsection 9D2 lowercase d. This is clarifying the 600-foot rule for required notice letters. That was a rule that was actually adopted by the board previously, however, for whatever reason was never updated into the formally filed rules. I thought it would be appropriate, since we're taking up these other issues, to clarify that once again so that we can adopt these simultaneously.
And we've been requiring it for
Absolutely.
a while, 600 feet among, from the property that you're applying for.
Absolutely. This will just make it a little cleaner in our formal document.
And the last one.
The last is from Rule 10, which is to add a new subsection number 4 that would specify that motions to rehear will be decided on the filings submitted by the movement and not on oral arguments. That had apparently been the original intent when a prior iteration of this board put that rule into place, that the rare motion to rehear would just involve the documents, just involve the evidence submitted that was in fact, at least allegedly, new evidence as required under our rules, and the board would determine whether or not it was enough to meet the standard and reset for a new hearing. This is one that is suggested for board's consideration, though staff takes no formal position as to whether or not that is a necessary outcome in this case. The specifically suggested language for the new 10A4 would be, motions to rehear will be deliberated and decided based solely upon the filings. No oral arguments or other presentations will be made to the board in conjunction with the motion to rehear. We would then renumber the remaining sections accordingly.
So what this does is just say you have to have something filed to kind of express why you should have a rehearing before coming here and saying, I want a rehearing.
That, but also there won't be a formal presentation or oral argument. It would just do it on the documents in the manner of a court deciding a case based on the filings.
But as an example, just to make sure I understand, we've had some council members come in and ask for rehearings. And so this addresses that issue. I mean, does the rule allow affidavits or anything of that nature? I just wonder if we would say affidavits are allowed, or
I would say absolutely they would be allowed in this scenario, not only affidavits, but full-blown formal pleadings from attorneys or from property owners or whomever else.
Okay.
I think what prior boards have been concerned about was the notion, and this is almost inevitable, as you've seen in other scenarios, on the rare motion for rehearing, the case gets reheard in the motion functionally, but you're only hearing from one party, not any opponents or not a council member who objects or supports. So this is a way to step back from a complete and total rehearing to decide if there will be a rehearing and then having a rehearing if in fact it's granted.
who is put on notice of a motion to rehear?
Only the movement.
So that I guess that's my point. So the other, nobody gets to oppose
Correct.
the motion. Okay.
And that's a bit of a, I mean, theoretically, I suppose someone could come and be present in an expression of their opposition, but right now, you wouldn't hear from those persons in your current rule of matter.
What do board members think about this particular one?
I think it sounds fine. I mean, there's an I mean, I think would we still have the right to ask questions?
I think the board will always have the right to ask questions.
We're just saying
believe
they
so.
don't have a right to make
I
an
think-
oral presentation, but if we wanted to ask questions because it wasn't entirely clear.
I think if someone submits some documents and we have some additional questions before we rule, or if it's an elected official, we could kind of ask them before we make, but that's up to us. But in general, it's just based on the documentation.
I think it's fine. As long as we can ask questions, I think it's really nice.
Okay.
So this is, I guess, different from notice, but when will it be publicly known that the request is being made to rehear, when that filing has happened?
Because it would require a board vote on the motion, it'll be noticed with the docket. So when the docket is publicly posted, typically the Friday preceding a Thursday board meeting, that's when the public would have information saying, okay, there's a motion to rehear the case, number 123 or whatever the case may be, at the next BZA meeting. The reason that we don't do a formal notice to neighbors for a motion to rehear is it is not a public hearing, so you do not hear from opponents on a motion argument. You just hear from the movement. Only if the motion is granted, as was the case at what I guess our last BZA meeting, a case was heard for a motion to rehear. The motion was eventually granted after lengthy discourse. And now it will be publicly noticed, signs will go up, notices will go out by mail, and they'll have their formal date for their formal hearing. Opponents who may wish to participate will have the chance to do so.
Okay, so it sounds like we're in general agreement of the 5 of these as proposed, so
Yeah, I don't want to open a can of worms, but there's the only other thought I had about, not on these 5, but a potential 6th, was that I do think it might be helpful if the chair, working with the board secretary, would have a right to order our agenda in a manner which they see fit, notably for efficiency. You know, I mean, if there were certain cases that we felt like needed to be at the top of the docket, or we wanted
or
to
bundling some
well,
types
or,
of cases.
you know, or if you have, you know, we have some of these 8 or 9 page agendas where you have SDRPs, you know, thrown all in between. You have sidewalks thrown all in the between. And if y'all look at this at that day and say the way to get through this day the fastest for the people that are here wanting to have their appeal heard, and for efficiency, for having consistency of mindset in terms of hearing similar cases at the same time, you want to group the sidewalks together, or you want to group the short-term rentals, or if you've got at the end of the docket something that's bringing out 60 or 80 folks, you may want to move that up to not waste their time, and not that the folks ahead of them their time wouldn't be valuable too. That's not that. But I just think if there's an ability to order the cases on certain days in a way that is efficient for everybody, I think that right should be had.
Okay. So what I was going to ask John Michael is how we should proceed on these now 6 kind of suggestions.
If you want to treat that as a 6th suggested change to the BZA rules and regulations, I would identify that as a rule placed in whatever appropriate section of our rules, declaring that the board chairman and secretary to the board will establish the BZA docket order in advance of public posting of the docket. I think that probably captures what you're going for. And the example that we think of sometimes is in the event that we have a staff member who is double booked for a court appearance or some other meeting. If, for example, our property standards folks.
Or sometimes a council person can come at one time but not another time.
Sure. There are things like that we can try to accommodate in a more expeditious manner.
And we've done that through a motion at the beginning of the hearing sometimes, but I think it makes sense for you all to.
Okay. So should we keep this open until another meeting, or should we vote on it? John Michael, what are you thinking?
It's been publicly noticed. The board, I'm perfectly comfortable with the board taking a vote on the matter, even here at the outset of the meeting, if you wish. Certainly, staff is eager to answer any questions board members may have.
Okay, any more discussion on the 6 things that we've discussed today, and does there anyone object to any of them? Okay, do we have a motion?
I'll move that we adopt these 6 concepts to the board rules and regulations.
Okay.
I'll second that.
A motion has been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously. Thank you for helping shepherd this, John Michael.
Sure. We'll make those changes to the actual document and file it appropriately with the Metropolitan Clerk's Office, who, of course, is the repository for board rules and regulations for all of our commissions and boards in the metropolitan
And
government.
before we get started, I know the Planning Commission and Metro Council has been discussing short-term rentals. Actually, they've been discussing them for a long time, but the past week or so, there have been public hearings where members of the public have weighed in on this. And it is on 3rd reading, I guess, from the Metro Council, so I invite the public, and I know a lot of people that enjoy watching the BZA on Metro Nashville Network are probably interested in what happens to this rule. So now is the time to contact your council person if you think that these short-term rentals should be expanded, reduced, the BZA's role should be increased, decreased. This is your chance as a citizen and a voter to let your elected officials know how you feel on this. There's a lot at stake, and so this is a good time for you to voice your opinion on social media, email to your councilman, letters to the editor if anyone ever writes those anymore. So thanks. John Michael.
Mr. Chairman, normally we use this opportunity to recognize any elected officials who are in the audience. Seeing none of our Metro Council members, we're happy to move on to the first case, if it be the board's will. The first case scheduled to be heard is case number 2017-368. Carol Turney is the appellant and owner of the subject property located at 1007 Delmas Avenue in East Nashville, Council District Number 5. This is an item A case involving a short-term rental property. The applicant had operated prior to obtaining the legally required permit and filed this appeal.
Please come forward now.
Is there anyone here in opposition to case number
Please sit
368?
at the table and press the button. Yes, no, you're fine, you're fine.
Seeing that there is opposition present for case number 368, the appellant will have up to 15 minutes to make the desired presentation. Ms. Turney, please feel free to save any of the time you may want for rebuttal purposes.
So press the button in front of you next to your microphone so the red light will come on. There we go. And identify yourself, your address, and please get started.
I'm Carol Ann Turney. I've never done anything like this before, but I'm going to make it through it. Did I understand Mr. Johns to say that I do have opposition other than,
Yes, there's one person that's
Yes.
going to speak in opposition. So you have 15 minutes. You don't have to use all 15 minutes. What will happen is you will speak, the opposition will speak,
Okay.
and then any time you have left over will be used for rebuttal, so you could respond to what the opposition has said. Okay?
okay, certainly. If I could just.
Oh, your name and address, please.
Oh, I'm so sorry. Carol Ann Turney, 1007 Delmas Avenue, Nashville, 37216.
Okay.
I was having a very hard time. I'm a single woman, quite frankly, making a living when the economy was in terrible shape. I heard about this thing people were doing. I was raised in Alabama on Southern Living magazine and my great-grandmother's fine china, and I loved the idea of hosting people. And so this kind of fit right in my wheelhouse. I love my home. It's a 1935 home, and it seemed like the hot thing to do, and quite frankly, it saved me. As time rolled on, I found out I needed a permit to do this.
Okay, so how did you find out and when?
I think someone told me that, they're making us get permits for this now. And I'm like, really? It's my home. I'm just having people in it. And I hadn't quite made that leap. And so it was always in the back of my mind as something I need to take care of.
So when did you hear that?
Probably 13, 14 months ago, something of that ilk.
Okay, so why are you now just in front of us and you didn't get a permit for that?
It is the proverbial kicking the can down the road. It was never meant in any way to be, what's the word? It was never meant to be in any way screw the government. It was never, pardon my French, I'm sorry if that was too rough. It was never meant to be defiance and over, it was just sort of, I really need to do that. But each month rolled along and I was okay. And then it became that it was the month that I simply was not okay.
The official
Indeed, I did.
enforcement agency of the codes department about this.
Indeed, I did.
And how did you hear about it and what did you do after you heard about it?
I got I received a letter around the end of the first week of November. And I immediately, the offices were closed for the day, and I immediately went to the website and found about 4 email addresses of people that I thought, and I said, I just received this. You will be hearing from me in the morning. And I immediately did. Of course, granted, all those came back to me a few days later. I didn't know that. And then I immediately, it's a little bit fuzzy to me, but I was definitely on the case. And I showed up, and it turned out that I found out that I had to be in a rotation, and so I signed up for the rotation and came the next morning, took care of it. Couldn't believe the level of discipline, but that's just too bad. Things are what they are, and I immediately began to comply.
So what did you do with future bookings? I mean, obviously you got this letter and you
I
probably...
shut that site down.
How'd you do that?
I called up Airbnb and VRBO, and I said, I need these sites down. I want to make sure they're down.
And so the future people, you canceled them?
There was one person who was coming in about 2 days, and I thought, I don't know how I'll make it through if I don't get that last pocket. The moment I shut down everything, they came, and then I even confessed this, and so I'm throwing myself on the mercy of that. But I have lost, if I could add to that I have lost a good bit of money saying I am complying. In fact, someone in a roundabout way tried to stay with me on New Year's Eve, and oh, the temptation was huge, and it was only going to be a couple of $100. But I said, I will not roll the dice. I will not disrespect this board. And so I have had about 7 or 8 weeks of massive no income coming in with no intention of defying, disobeying, ignoring. I just thought, please let me let that last one skate. It's just 2 days away, and then I'm going to, and I promise you, I have lost a tremendous amount of income in lost opportunity costs. I'm not here to complain about it, but I have, I feel like I'm 98% compliant, and the 2% I didn't feel good about at all.
Okay, so questions, board members? So you understand, I'm sure someone explained to you during this whole process, that if you're in violation of the short-term ordinance, and we're not the legislative body, we didn't write this ordinance, that you are supposed to not be able to rent or basically apply for a permit for an entire year. The reason that you are in front of us
Yes, sir.
is because you're trying to ask for less than a year.
Yes, sir. And apologize.
Okay.
And say, I'm sorry, I get like that. I'm really sorry. And I'm wanting to go back to school, potentially. I'm a creative person. This has saved me. I cannot express it. It has saved me. It has made me able to keep my home. I've been able to be okay because I had a family member pass away late October, and I inherited a small but significant enough inheritance where I have been able to carry myself, and I've been grateful for it. And I am asking as nicely and as humbly as I can. This will negatively affect me. If I am asking for mercy, and I go forward with the expectation of completely complying and staying completely within bounds of this board's jurisdiction of what is acceptable and what is and not doing that which is unacceptable. And just in layman's terms, I'm really sorry. I truly didn't mean it as an act of defiance.
Okay. Any questions before we hear from the opposition? Okay. Just please go back there, and we're going to have the opposition come forward, and then you'll
Go
have...
back where, sir?
Oh, where you were sitting.
Okay,
And
thank you.
then after the opposition, you'll come back and you'll be able to respond. Okay, so please state your name, your address, and why you're in opposition of this particular case.
Hi, my name is Omid Yamini. I live at 1204 North 2nd Street, Nashville, Tennessee, 37207. As we've gone over before, because you all know me, I'm not here in opposition. I'm here asking you to enforce the rules that you have on the books. Okay? That's all I'm here doing. And, you know, I watched last week's, 2 weeks ago, BZA hearing. It kind of seems like we've kind of gone back to a catch and release format.
We're not here to talk about other cases. We're talking about this particular case today.
Then let's talk about this particular case. What are we here to discuss? Whether or not the person operated without a permit, correct?
So why are you in opposition to this, outside of we should enforce the laws in general?
What I'm in
about
opposition
this
of is the
particular-
fact that I'm concerned that the rules are not going to be enforced unless someone's sitting here watching them be enforced. I'm here watching.
Okay.
You know, basically, from what I understand, again, all we're here to talk about is whether or not the person operated without a permit. And that's been clearly stated, correct? Okay. And so the only thing that's...
But we have the ability to balance for now this particular applicant versus other particular applicants, party houses that you're aware of, people that have numerous complaints.
The way I understood it, you weren't here to talk about behaviors, and that's really where I get a little bit confused, because if I talk about behaviors or things going on in houses...
This particular applicant and your knowledge of
but you're talking about party houses now. Why did you bring that up? That's not the issue.
I brought up party houses because we are here to weigh this applicant as every other applicant. And how this might be at one end of the scale and a party house might be at another end of the scale. And our job, because the Metro Council has given us this ability for now, is to weigh that and to see if there are any mitigating circumstances in this individual case. That's why we ask for the applicant to speak. And if you know any circumstances about this individual, why we should or should not rule in a certain way, we're here to hear it.
Just so you know, this is an appeal panel. People can come here and appeal, and that's what it's all about.
That's what it is, right? So essentially, you guys, again, we've spent $2 million for the people out there who maybe don't know on this host compliance software, right? And we're now seeing the host cases come before you, correct? All of that money and all of those resources and the people that are sitting over there who are being paid to go out and catch these people who, in some cases, including this one, admittedly knew they needed permits and didn't go get them.
Do you have anything else to add?
Are being, well, I would be curious to ask this.
We're not actually here to ask questions.
Well, you just asked it. Okay, do I have anything else to add?
Yeah.
Okay. Well, I do have something else to add. I am a little bit curious as to what circumstances would lead to a member of the BZA having an interest in a particular topic or case and needing to recuse themselves. Could I ask legal counsel for some explanation?
You can, but the board doesn't give advisory opinions.
How do I get that information?
You can hire a lawyer.
You'd like me to hire a lawyer to talk about the BZA? Is that what you're recommending?
We're not here to give you legal advice.
If staff may intervene, the board doesn't do advisory opinions. They just rule on the cases before them. The case before them has to do with whether or not there's a violation, a question that's been largely put to bed by the documents in the case file, and whether or not, under the law's provision for them to do so, to reduce the one-year wait period by any amount, what amount, if any. There's only two questions before the board. Neither the board nor Metro's legal counsel nor Metro staff issues advisory opinions with regard to legal questions. However, if you have questions about the board's rules and procedures, you're welcome to take that up with staff at an appropriate time. And forgive me for saying inappropriate time, just not in the middle of a board meeting.
Absolutely.
Obviously, we're not in a
I
position to take up
appreciate that.
generalized questions
I
on a
appreciate
specific
that.
case.
Okay.
So I'll go back to this particular case. What I'm asking you to do is to please enforce the rules that are on the books.
So you're
That's
saying
it.
a year punishment.
Again, we're not taking away someone's property. They have the ability to rent the property. They can rent long-term. There are ways to make income with the home other than going short-term rental. Okay, so we're not taking away someone's toy. We're not doing anything that's permanent. We are just changing what they are allowed to do based on the laws that we have on the books. That's what I'm asking you to uphold. Thanks for your time.
Okay. Thank you.
I've got a question for our legal counsel, because the opposition had made the claim that we are not doing that we are not upholding the rule as written. And so, and I certainly understand very much, because he's been here before, that he doesn't agree with our rulings. And I certainly respect his right to have that opinion. But the claim that we're not following the rule is, I think, a serious one. And so I just wanted to make sure that I asked our legal counsel, and I think you've been here for most of the cases that we've heard, but to your knowledge, have the decisions that this board has made on short-term rental cases followed the rules that we are bound by?
As long as I have heard any of the cases, this board has followed the law. A previous iteration of the short-term rental ordinance required this board to impose a one-year waiting period if there was a violation of operating without a permit. And at the time when that was required, to my knowledge and recollection, anytime y'all found someone had operated without a permit, you did impose the 1 year. At some point, I don't know the exact date, I think February of this year, the law was changed, and it gave the current state of the law gives this board the discretion to impose up to 1 year. So since that has changed since February, any time you have given less than a year has been based on a number of factors that you are specifically allowed to consider according to the current state of the law.
And that's why I said at the top of this meeting, contact your council person, write a letter to the editor, get involved. This is important to the future of our city. If you feel one way or the other about that, we're not the ones that make the laws. The Metro Council will be. So no matter how you feel on this, talk to them and get involved. So we're going to hear from the applicant again, and you could respond to the opposition.
I would like to state that I as well am a lover of the law, and I do believe in enforcement of law on the books. I had a very informative and extremely clarifying conversation with Mr. Johns when I was going through the part of this process where I was none too pleased, which is just sort of part of your initial.
I did not do something. Let's hear from our enforcement staff about this case and how this came to our attention, which I have a feeling I know, and was there any other complaints? So Mr. Osborne, our enforcer, how'd you hear about this?
This was one of the many that host compliance has provided.
Host compliance, we're getting our money's worth.
We are.
Okay, so how did we hear about this?
Haven't received any other complaints about this one.
No noise complaints or anything else?
No.
So you sent out this letter that she's referring to?
Yes.
Okay. Any questions for Mr. Osborne?
What was the date of the notice?
I believe the
Does it
first
have
one
a-
went out October 27th.
When? Sorry.
I believe it's October 27th.
Just that?
I
Okay.
missed that letter.
Okay, but that's what he says, so we're
I
going
don't
to go by what he
disagree.
says, okay?
Yes, sir.
Okay.
Yes, sir.
So please, any questions, other questions for Mr. Osborne? He's looking at the date of the notice.
Am I to be,
No.
I'm not to be talking right now.
Not right now. We're talking
okay,
Mr.
I'm sorry.
It looks like the first notice went out October 27th for
Okay.
not having a short-term rental permit and not paying the taxes on it.
Okay.
And then another letter went out the end of December for not paying the taxes.
Okay, very good. Now you get to speak.
Okay. I appreciate, again, like I was saying, the rule of law. I'm also learning to greatly appreciate the opportunity to appeal, ask for forgiveness, turn over. It was never a defiant leaf, but to turn over a greatly informed.
But you did operate without a permit.
Yes, sir, I did, and I was wrong.
Okay.
Yes, sir.
Any other questions for the applicant? Do you have anything else to add?
Well, I did lose, and this is my doing, approximately $200,000 of lost income, lost opportunity.
I'm really confused. I know short-terms are lucrative, but $200,000?
Did I say 200?
Yes.
Erase that, please. 2,000. I'm so
Okay.
sorry.
Okay.
I wouldn't have. If I were making that, I could have retired. But like I was saying, I had a very informative and clarifying discussion with Mr. Johns, and I found everyone at the office to be very helpful and not. They were just doing their jobs.
Yep. Okay.
Through this process, I'll be fast. Through this process, I learned the other side of the argument. And I've come to greatly respect that and understand that. And I wish to do whatever it takes, if you will please let me go back to doing this, to make sure that my neighborhood flourishes rather than is in any kind of decline because of my doing what I do.
Okay.
Thank you.
Thank you. Let's close public hearing
Well, I'm going to start off by saying that I recognized Carol Ann because she temped for my office, and as she was speaking, I realized that she temped for my office. So I don't want to, I don't wish to vote on this matter in case
So you will
should come.
recuse yourself? Okay.
Yes.
That's fine. Discussion. So here we have the first of many cases today of somebody operating without a permit that hosts compliance has discovered. So,
And as I said earlier, this is an appeal board, and I'd like to know her reason why she did not comply with the law.
okay, well, let's reopen.
Yes, sir.
So you admitted that you found out almost a year before you got even a letter from us, and I think the words you used was kick the can down the road.
Yes, sir.
Why didn't you come in to get a permit?
For foolish reasons. I'm embarrassed. I am trying to answer your question, but the best way I know how to say it is I really meant to. And then it always seemed like the month was tight. I can do this next month. I will confess openly that I don't think I realized the ramifications of it. I am not trying to in any way justify what I did. What I'm trying to do is come and say, Uncle Mercy, my sincerest apologies. I had no idea that I was being disrespectful in any way. I simply, I live where I live in my head, and I simply failed and did not comply.
For the rentals that you had, did you pay any taxes?
No, sir, I did not. And I'd like to quickly add, I had no earthly idea about the taxes. I would have hastily handled that. And that's nothing I would have ever.
And you realize you owe back taxes.
Oh, I know. Yes, sir.
Any other questions before we reclose the public hearing?
Are the back taxes paid? You've had an opportunity to have those calculated?
I waited for everything until I came here to get crystal clear instructions and begin immediately to complying with those instructions.
Yes, ma'am. Have the back taxes been calculated?
Not yet, ma'am.
I thought, Mr. Osborne, can you come back? You said that she got a letter from the tax people last month. Is it just you owe taxes, or do you owe this amount of taxes?
It tells them that they need to contact finance to.
Okay, so it says that you owe outstanding taxes. It doesn't say how much.
Right.
Okay.
Okay.
We will reclose the public hearing. Discussion.
So I know previously, I know you've been particularly careful about how or help us be careful in how we analyze these things so that we can find some consistency in our deliberation. And I mean, I believe the testimony is 12 or 13 months that she admits that she has known. And so, I mean,
And the rental after she did that.
right, and so I think this might be a case for the full year. But I'll entertain other arguments.
Well, let me ask, I was thinking while she was talking, I do think this is a case, a lot of times we've done a 4-month for what we find to be the least onerous offenders, but she clearly knew she was in violation of the law and she failed to follow up. She still rented another time without knowing, after receiving the letter. And now we have a situation where, she owes money to the government as a result of that. And so I sort of wonder, and maybe this is for legal counsel, if we have the ability to say she can't reapply until X date, or the payment of the back taxes.
I
think the taxes are a separate issue from this board. This board deals specifically with operation of a permit and receiving that permit. So I think the taxes are dealt with by a different department and need to be paid regardless, but I don't think there's a specific set of criteria for this board to consider, and the taxes, I don't believe, are in there.
Thank you. And I think that something that I don't think it's specifically set out, but I still think it would be, or do you agree that it's a factor we can consider whether or not they have paid their taxes?
I think you probably can consider it. I'm
Okay.
not sure. That turned off. I think you can probably consider it. I'm not certain it would be proper for you to say, if you pay your taxes, then you can get your permit. But I do think if that's a factor that you want to consider in determining how long the permit should be prohibited or should be unable to be obtained, then I think that could be a factor for you to consider.
Well, I'd like us to consider the fact that she did testify that she didn't realize that the permit included a payment of tax, and that if she had known tax was involved. And, if somebody tells me you've got to get a permit to do something, and I haven't looked into that, I may not know what that permit requires. That's just something I think we should think about.
Well, I was kind of thinking too, I mean, if I divided that penalty into thirds, I was, felt like to me it was that middle third range, mainly because I think of what are the other permits that you have that, it's a $50 permit. It's not expensive. There's a process. The process is important. It's, but there may be signals to say, I got to do that, whatever. I get that, but I also think those two factors really play into it. I do. It's not related, but we talked about that. The system is this computer system is finding a lot of these things, and it was an expensive system. But the way the city pays for that system is to frankly get people compliant and paying their taxes, and to have everything above board. So I think it's in the city's interest, especially with the type 1s to get folks into the system. But I think that the evidence here says that no, there was some knowledge and some willingness to violate a law that was known.
Does anyone have a motion?
I think to be issued a permit, they have to be in full compliance with the laws. Am I wrong?
So ask our lawyer, to get a permit, do they have to be current on their taxes if they operated previously without a permit?
Well, if they operated previously without a permit, they cannot get a permit.
Right, but if
one
we
of the factors,
allow them to...
one of the factors that, in order for someone to be granted a permit, one of the factors is for them to state or to clarify to the zoning examiner who receives the application that taxes have been paid. So if you all allow them...
So that's part of it?
That's part of the application process. So if y'all, whenever you determine that that a permit can be granted, it's eligible for a permit. So y'all routinely say you're eligible for a permit, you still have to go apply.
Right.
One of the steps in the application is
payment
confirming that you've paid your taxes.
Gotcha. Okay, that being said, anyone have a motion?
I'd like to move that the zoning administrator did not err in denying the permit, and that we allow her to be eligible for a permit 6 months from the last rental that she had.
Motion has been made. Is there a second? Motion's been made and properly seconded. Any discussion? Seeing none. All those in favor of the motion signify by saying aye, and we have one abstention, and also I want people to raise hands.
Okay.
All those in favor of the motion signify, raise hands, and say aye. Aye. Opposed? Anyone else have a motion?
I will move that we deny it and go for the full 1 year, which is what the law says.
Okay, motion's been made. Is there a second? Seeing no...
I'll second that.
Oh, motion's been made and properly seconded. Any more discussion? All those in favor of the motion, once again, we have a board member abstaining, signify by saying aye and raise your hands. Opposed? Okay, motion fails. Another motion. I move that the zoning administrator erred. I agree with Mr. Taylor. I'm sorry, the zoning administrator did not err. I agree with Mr. Taylor that this is probably in the middle third of kind of violations, and that the person should be eligible to apply after 4 months of the date of the letter. That's my motion. Is there a second?
I'll second.
Motion's been made and properly seconded. Any discussion? We have one person abstaining. All those in favor of the motion signify by saying aye and raise hands. Aye. Opposed? Okay, next motion.
I'll take a whack at it. Let's say, I move that the zoning administrator did not err in his decision, and the applicant will be eligible to apply for the permit 8 months from the date of the notification.
Okay, motion's been made. Is there a second?
8 months from the date of what?
Notification.
I'll second that.
Motion's been made and properly seconded. Any more discussion?
Is that clear enough? I mean, staff, is that okay?
Once again, we have one person abstaining. All those in favor of the motion signify by saying aye and raise hands. Opposed? Motion passes. Okay, John Michael.
Mr. Chairman, one case appearing later on the docket is case number 2017-385. It involves a short-term rental permit at the location 916 14th Avenue South. Staff, upon further review with the Property Standards Division, has identified that this was errantly marked in our CityWorks software, indicating that the permit was in fact expired when it was not in fact expired. Hence, when host compliance ran through their cross-check, saw that it was marked as expired, they thought they had a violation. Since we have been able to confirm that payment for the renewal was timely made and all criteria met, that is a case, again, case 385, that can be withdrawn from today's docket. The matter will be handled internally. There is no new permit that need to be issued, and Mr. Rob Benschoof, the appellant on case 385, will be free to go with the matter now resolved.
Okay, we're going to take over starting next case, and Mr. Taylor is going to take over too.
All right, Mr. Vice Chairman, the next case to be heard by the board is case 2017-374. Ms. Rebecca Snow is the appellant and owner of the property located at 2219 11th Avenue South in Council District Number 17. This, too, is an item A appeal involving a short-term rental permit. The applicant was accused of having operated prior to obtaining the legally required permit. The aerial map here is showing the neighborhood and the face of the property with a photograph from the assessor's website. The representative from Ms. Snow's case will have the opportunity to make a 10-minute presentation to the board with regard to this appeal. Is there anyone here in opposition to case number 374? Seeing no one, please introduce yourself by name and address and make the desired presentation.
My name is Craig Snow, the husband of Rebecca Snow, at 2219 11th Avenue South. She would have liked to have been here, but she threw her back out last night, so she was unable to be here. She made all the application and the represent. So on September 8th, 2015, we came in to apply for a short-term rental. We knew that this was an important part of the process. I have in my hand the information that the Metro Codes gave us, identifying that a zoning review and a fire safety review needed to be obtained. We had the fire marshal representative come out and inspect the property. We obtained our business license and have been paying our hotel occupancy tax since operating it. We assumed we had done everything that was required of us.
So you came to this building and got a business license?
Yes, sir.
And do you have a copy of that business license?
You know, I thought it would be on record, so I didn't think to bring it. It's Snowed In is our business license name.
You're not the first person to come before us who, if I'm hearing you correctly, got the wrong license or a license instead of a permit. We have seen this.
It's a handful of times.
And you've been paying the appropriate you've been paying a tax.
The hotel occupancy tax.
Right, and I'm not a tax expert.
And all the taxes that are associated with a short-term rental.
So give us a brief history of, I'm assuming you have a site somewhere, Airbnb or
Yeah,
VRBO?
in our house. We rent out a portion of our house. It's an owner-occupied.
And so, when did you get noticed about this from the city?
We got our letter from the city. That's,
In case it helps, I believe that's the October 27 letter generated
October-
by host compliance, October 27.
October 27th.
And
So we came in right in to find
I
out.
was reading as you were giving your introductory remarks. I'm sorry, I don't multitask well.
So what we were told is there was a $50 fee that we didn't pay.
Right, and so what about the rental history?
What did you do after the 27th? Did you cancel your rentals, or did you?
Yeah, we informed Airbnb.
And you've rented this for 2 years, thinking you had a license?
We thought we had a license, and we thought we had complied to everything, but apparently the $50 fee wasn't paid. And in this letter from Metro Codes, it doesn't identify as that being one of the steps. Now, that was maybe handed to us verbally, but my wife isn't here. She doesn't recall that. We tried to cross all our Ts and dot our Is, and we thought we had.
And it's your testimony that you canceled your rentals that were scheduled after October 27th of last year?
No, that's not my, we pulled it off Airbnb, and we let the people that had reserved, and again, I didn't, until the first testimony, I didn't know we needed to. My wife handled it. I'm sorry for that, and we're willing to
So
do
how many rentals would you say you've had since?
We probably had 5, and I can verify that. We did go ahead and pay the taxes on those, so I have a record of that, and if I need to compensate.
And John, Mike, I'm sorry, did you ask if there was opposition to this case? I did. Okay, all right.
Does anybody else have any questions for that? Is there anything that you have to add?
Yeah, I just want to say thank you. Thank you for the opportunity for residents like us to have this opportunity to do short-term rentals. So I just want to go on record saying thank you, and whatever your decision is, we'll comply.
Great, thank you. All right, we'll close the public hearing.
And Mr. Vice Chairman, you may want to hear from staff, property
I'm
standards.
sorry, Robert.
So this is another one that we found out through host compliance. It looks like they did come in and apply for the permit back in 2015, but however, everything was met but the payment.
And so, okay. So is there anything else from the applicant's testimony that didn't jive, or that you had any comment on?
It appears he's been paying his taxes because that was left out of the letter that was sent to him.
So it was accurate. The only thing lacking for them was the $50 fee had not been paid?
Yes, ma'am.
Okay, thank you.
And one other point from staff, at the permitting level, although the fee was not paid, and yes, that is lacking, the absence of a payment means you never had a physical permit in your hand, and that's kind of just the final little blessing on that. So everybody knows when they walk out, or their representative knows, I have a permit in my hand issued.
All right, this time we will close the public hearing and note that this is very similar to cases that we've heard where people went through the proper process and then came to get a business license instead of a short-term rental permit, thinking that they were doing the right thing. Any thoughts?
My only thought, which to me would make this slightly more than what we have done on the least onerous offenders, is that he did have at least 5 additional rentals after knowing that he was not in compliance. And so we have often looked at the people who canceled those rentals and given them our greatest leniency. And so that would be my comment.
It's rare that we get the perfect storm of ignorance and compliance. And I think what you're saying is right. I mean, it oftentimes people's first instinct is to cancel it, and well, it's just I've got one this weekend or whatever. But I think there's sort of no excuse. There's not the ignorance of the law excuse, which isn't an excuse. I get it, but I think that really has to be weighed into it.
That tug of Southern hospitality versus following the rules. If I don't want to upset my guests coming in, but at the same time, I need to do the right thing.
So, but I mean, I am, having never gone through the process myself, I'm a little surprised and not surprised that you can get the wrong permit. So I do have sympathy, but I feel like this is probably in the 6-month range. The 6-month range. I don't know. What do you guys think?
And I think it was a totally honest mistake. I think the only mistake was having the rentals. If they had 171 reviews over 2 years, that averages out to be about 7 a month. They rented it 5 times after. It's been 2 months since they received the letter. So they basically gave up a month. They added a month to it. So I think if he had said he didn't rent it at all, we would have said he could have his permit tomorrow. And so to go from tomorrow to 6 months, I think is extreme.
So what do you think? Rather than making 3 or 4 motions, where would you cast your bid?
I think again, based on his average rental history of that being about a month, I would say if it were not for that and that were to be 0, I would just say it a month. But if you wanted to say a month from today, the end of January, then that actually is more punitive than time served. But again, you have someone who followed the rules, got the fire inspection, did everything right, went to Brenda Wynn's office instead of the code's office, or maybe you go to the same spot, I don't know, and paid all their taxes. They thought they were following the rules, and the only mistake was that they didn't, they didn't stop at exactly when they said they were, when they were supposed to. Now, if it was more than 5, then would that make a difference? I don't know. If it was rented yesterday, would it make? I don't know.
I want to clarify something you said. A business license is applied for in Clerk Brenda Wynn's office. A permit for a short-term rental is applied for in the Howard office building. If I understand that correctly, Mr. Herbert could tell us that. But I want to make that very clear so people will know they're going to the wrong building to get a short-term rental permit if they go to this building. This is not the place to go.
But I do think that, the other folks that, again, how much penalty you want to put on not stopping is, I guess it's up to the motion you want to make, but to me, this is a pretty minor violation with that considered maybe on top of that.
I was going to suggest 4 months from the date of filing, which was November 8th.
I wouldn't go lower than that.
Someone want to make a motion?
So I'll move that the zoning administrator did not err and that the applicant be eligible to apply for a permit 4 months from the date of the filing, which would be March 8th of 2018.
Is there a second to that motion?
I'll second it.
We have a motion. We have a second. Any other discussion? All in favor of the motion, raise your hand and say aye. Aye. All opposed? It passes 5-1. All right, next case.
With case 385 having been withdrawn, the next case to be heard by the board is 2017-391. Matthew Asklund and Deborah McCool, the appellants and owners of the property located at 401 North 17th Street.
John Michael?
Yeah.
I'm sorry, it was 379 pulled?
379, I think.
Or if you want to hear them in order, Mr. Vice Chairman, then sure. Case 2017-379 is the next case. All apologies to both the 379 folks and the 391 folks. Rachel Hamilton is the appellant and owner of the property located at 1123 Sunnymead Drive. This is in Council District Number 7. This is a request for an Item A appeal, another short-term rental property operated prior to obtaining the legally required permit. And forgive me for not having the slideshow presentation queued up for that one. Is there anyone here in opposition to case number 379? Obviously, the board will hear from staff momentarily. However, in the absence of opposition, Ms. Hamilton, you'll have the opportunity to make a 10-minute presentation to the board if you need that. Please introduce yourselves by name and address and make the desired presentation.
Thank you. My name is Rachel Hamilton. I live at 1123 Sunnymead Drive, Nashville, Tennessee, 37216.
And I'm her husband, Bill Rios.
He also lives there. So we are in a very similar situation, as you just heard. We actually started doing Airbnb way before there were any rules of any kind, way back. So when we got notice about the taxation, which we did back in 2015 now, something like that, we started paying our taxes immediately. We received a number to pay those taxes, and we have been paying those taxes faithfully every month since then.
So you got a business license?
Yes, we have a number, and Bill can pull that up on your phone if you'd like it. So we have been paying taxes since then. We thought we have a number, we pay taxes, we're all good. Wrong. We got a letter, just like everyone else here probably, and in which case we, with post haste, got all of the required documentation from our neighbors. We drew up a ground plan. We did all the things we were right in, and of course we were denied because we were. Sorry?
No, I'm sorry.
I saw your light go on. So we just want to rectify this as quickly as possible. We want to be in compliance, and we're just here asking for a reduced sentence because we truly thought we were doing everything right, and I apologize that we weren't.
So this is your personal home?
This is our, yes, sorry, this is a room.
I think I read on the documentations that it's a, you have a 2-guest maximum, 1 bedroom that you rent your home. So you all generally are there when you rent your home?
Always. We actually never rent when we're not home. We don't trust people with our cats. As soon as we got the notice from Metro, like I said, we started collecting all the documentation. I think we did it within 2 or 3 days. Because we know all of our neighbors and the landlords who own all of the properties around us. We unlisted the property and then went in to apply.
Did you rent it at all after you got the letter?
So we had guests in our home when we got it, so we did not kick those people out. And then we had 1 rental on New Year's, which I felt super bad about canceling. And then we have an upcoming one, which we haven't canceled for the outcome of this. That's actually not till Fan Fest in June. So I haven't canceled that, but pending this appeal, we would cancel that.
Any questions? Okay, who has this one?
So this is another one that was brought to our attention by host compliance. The letter was sent for not having a permit and taxes, so I'm not sure how they track the tax part of that, but we'd have to find out with finance.
No complaint.
No, sir.
Any other questions for Robert? Is there anything else you'd like to add?
No, but thank you for letting us speak to you today.
All right, we'll close the public hearing. Thoughts?
That's important to me, and I know it's a hard business situation, but that doesn't sway me. I mean, we have rules and they need to be followed. So I take that into consideration. Otherwise, it sounds like they've complied and there have not been any complaints about them. Those are my comments.
Any other thoughts or a motion?
Well,
I'm sorry. The future reservations bother me. Actually, more so than it bothers me when they continue to rent, but to keep things on the book, that kind of bothers me. If we have to, we'll cancel it. That kind of bothers me a little.
Well, I mean, I think if it does, I get it, and it does me too. But if it were in February, it'd bother me a lot. The fact that it's in June is like, there's still plenty of, there's plenty of time to cancel, and it may be cleared up by then. I mean, I get that piece of it. I mean, I think if you, and maybe it's splitting hairs, but to me, I think the fact that it's that far out for, and it's not as bad, but I agree, it is a concern.
Okay. What do you think, Mr. Harper?
None of my suggestions have worked today.
Now's your chance.
Yeah, I still feel like it's a 5 or 6 month thing.
Make a motion.
I'll move that the zoning administrator did not err in his denial of the permit, and we find that the applicant will be eligible 5 months from the, what did I say last time?
I think it was either the date of the letter or the date of...
From the date of the letter.
We have a motion on the floor. Is there a second?
I'll second.
Okay, I just want to have a quick discussion. So on the gentleman before that had a business license, as these people do, who had rented 5 times after, we gave him 4 months from the date of the letter. I do not necessarily think this case is any different. If anything, it is less, but I don't think we have to split those hairs. But
well,
what am I?
Right, no, I think for purposes of the appeals court arguments, I think that still having, for me, the appointment still on the books is mitigating that additional month.
Yeah, I mean, I tend to agree with Cynthia that it's the 4, or I don't see it as different enough from the previous one.
I tend to agree with that as well.
Would you consider changing your motion?
I'll accept an amendment to it if somebody wants to.
I would move that we amend the motion to 4 months from, did you say the date of notification?
Of the letter.
4 months from date of, I would amend the motion that the zoning administrator did not err, and they would be allowed to apply for an application 4 months from the date of notice.
And David, is that acceptable to you?
I'll accept that.
Can I also amend something? I think it should be from the date they file with Metro, and because it takes a while sometimes for people to come down here.
Okay. I would agree.
Is that okay?
Is that acceptable to you, David? Dick?
Absolutely.
Okay.
Do you have that motion?
Did you follow that, John Michael?
I got it. Yeah, okay. We have a motion on the floor. We have a second. Any more discussion? All in favor of the motion, say aye and raise your hand. Aye. Any opposed? It passes unanimously. You'll be eligible 4 months from the date that you came down to make the appeal.
And that was November 8th?
November 8th.
Thank you. Great. Thank you
Thanks.
so
Good
much.
luck.
We really appreciate you.
Mr. Vice Chairman, the next case is 2017-391. Mr. Asklin, Ms. McCool, the appellants and owners of the property located at 401 North 17th Street. This is an item A appeal challenging the denial of a short-term rental permit based upon prior operation to before obtaining the legally required permit. Neighborhood shown here, face of the property shown here. Parties are represented by counsel. For those who will address the board, please introduce yourself by name and address. We'll ask on the front end, is there anyone here in opposition to case number 391? There is, very plainly demonstrated. Therefore, the appellants will have 15 minutes to make the desired presentation. Feel free to save any portion of that time back for rebuttal if you wish. Then the opposition would have 15 minutes as well.
If you could, state
Good
your name.
afternoon, Mr. Vice Chairman and ladies and gentlemen. Matthew McIntyre, 6009 Kenwood Drive. My office address is 2809 12th Avenue South. I represent Matt Asklin and Deborah McCool, and I'll let them introduce themselves.
Matt Asklin, address is 401A North 17th Street, Nashville, 37206.
Hi, Debbie McCool, address 401A North 17th Street, Nashville, 37206.
Thank you for your time, ladies and gentlemen. This is a little bit of a unique case compared to the ones that you typically see, in that we are here appealing the cancellation of an issued permit as opposed to the denial of an application. And I'll I'll address first maybe the procedural way we got to be here, and then kind of address more of the factual scenario.
Yeah, can I ask a point of clarity? Because on the agenda, it says that this is just you operated prior.
Apologies, this is a cancellation dated back from late summer, and I know that Mr. McIntyre will be able to explain the pertinent dates, but I believe it was July 27 was the 15-day notice that was sent out, and then in August 11th, final cancellation that followed. This is an appeal of that cancellation rather than a mere traditional appeal of a denial of an application, if you think of it in those usual cases. So this is somebody that had a permit. Again, I don't mean to step on the toes of counsel who will present his own case very capably, but this was a permit that was issued and then later canceled, and the details will be in your case file to some extent.
So, and the purpose of the cancellation is part of their case here?
The details of the cancellation, I'm sure, will be covered in thorough detail by counsel.
Got you. And I'll go ahead then and kind of address how we got here. This is a type 1 owner-occupied situation, and it goes back before host compliance was a dream in Mr. Osborne's eye. It goes all the way back to Mr. Asklin and Ms. McCool are a married couple. They bought this house in December of 2015 and have a unique situation where they're a married couple. They have a long-distance relationship. Mr. Asklund got a job in Phoenix with a Brentwood, Tennessee-based company where he handles a branch in Phoenix. And they decided to They bought this new house in in December of 2015, and looked into renting their home. They had had a good experience with VRBO, having been a tenant of a VRBO at one point years before, and they thought, hey, maybe this is a good thing. This kind of fits the situation of when we go to Phoenix to be there with Mr. Asklin's job, we can rent out our house while we're gone, come back and be in it. This is our home, but we let other people stay in there. Kind of really, I think what this whole short-term rental was initially designed to accomplish. To the extent that they bought the house in December of 2015, sometime in mid-2016, they started investigating how can we rent this. And to the extent they had any limited awareness of kind of the new regulatory regime around short-term rentals, they were not aware that anything would apply to someone trying to rent their own residence. And while that may seem hard for the board who deals with these regularly many times a day, back in mid-2016, that was not an unusual situation for just ordinary citizens. They listed their home on VRBO primarily. I believe they had it on Airbnb also. And at some point in March 2017, they received a stop work order on their home. It had Mr. Osborne's telephone number on it. They call and say, Mr. Osborne, what do we do? And Mr. Osborne helpfully advised them, take it down and get a permit. So they immediately, and this is again back in March of 2017, took their listing down and went and applied for a Type 1 permit. That permit was granted in April 17 of 2017, permit number 2017021270, and I imagine that permit is in your file, but it's possible that it's not. But we have copies if that permit is not in your file. So at that point,
do you want this? Do you want this copy?
Yeah, that's fine. We have copies for everyone. So again, immediately after speaking with Mr. Osborne, seeing that stop work order, they do exactly what we want them to do, take their listings down, apply for a permit. They did. That permit was granted in April. Now, the unusual situation is, at some point, Codes Compliance had issued a citation that never reached Mr. Askland and Ms. McCool. There was a environmental court date in May that didn't go forward because, I believe, lack of service of that citation. That citation was reissued and served on them sometime in August, and there was a September 2017 hearing date for that environmental court date. When they got that August citation, again, they immediately took their listings back down. They met with council, and we met with Metro legal attorneys at the day of the hearing, and counsel for Metro provided us with a late July cancellation letter that Mr. Askland and Ms. McCool never received. But we discussed kind of the unique situation of this case, that in fact they did what they were supposed to do and actually were issued a permit. Now, I think in some situations they wouldn't intend to issue a permit, but they did. And so they operated under the permit that we've provided to you.
Well, wait, what was the environmental court citation for?
It was for operating previous to the April 18 permit date.
And then what was the outcome of that environmental court hearing?
So because of the unique situation of the case, we discussed it with counsel for Metro, and they agreed that this might be one of those rare cases where it's more appropriate to handle before this board. And so they agreed, if we're willing to come before the board here, they will dismiss the environmental court case, and we will handle it as this board determines.
One point of clarification, my understanding is that this case is still pending in environmental court. It has been continued so that this board can act, and depending on what this board decides, it will potentially be dismissed, but it's not going to be dismissed just because they're before the board.
And is the environmental court case because there was rentals between March when the stop work order was issued and April when the permit was issued, or was it prior?
It was prior to the March. And I think Mr. Osborne, I'm sure, will tell us when that violation was about. But the discussion with, I might re-clarify, the discussion was we will all agree to whatever the board decides, and then the environmental court case has been continued just to make sure that Mr. Askland and Ms. McCool did intend to come before the board, not just that they intended to go about their merry way and pretend like this never happened. They've agreed they'll pay whatever court costs, and then that will be dismissed, but we will accede to whatever this board's.
Has this home been listed or rented since August?
No. So this was taken down, it was taken down all the way back in March when they got the first stop work order. It was relisted in April, and then it was taken back down in August or September when they got the second violation. Now, the cancellation happened, Codes and Zoning has a August 11 cancellation letter. So that's presumably the date of the actual cancellation.
Okay, so it's your position that from mid-2016 is when your client started advertising, and was that when rentals began as well?
Sometime in that neighborhood.
So, and then you were not in compliance, and when did you? Then you got a notice in March of 2017, so 8-9 months or whatever of noncompliance, and then you thought you had a permit from April, so the rentals during that time you are saying, to your mind, you were in compliance until the next notice, because you did not know about the May citation. So as far as you know, since it's your position that your client, question mark, is your client's position that as far as they know, they were not, well, they weren't knowingly out of compliance once the permitting process started, canceled.
That is correct. Okay. And so, because they actually did have a permit. And so there was really no reason to believe in their minds they had done what they were told to do, and code zoning gave them the permit and presumably
So the only letter you're saying that they didn't receive was the July 7th or 27th letter?
Actually, they will tell you they didn't get either letter. At that,
either letter of which?
There's a July 27th letter that says you have 15 days,
right?
And then there's an August 11 letter that says the permit's canceled. I actually received that from Mr. Michael by email. When we had the September hearing, we hadn't seen the July letter. Counsel for Metro Legal gave us a copy of that letter. So that's when we received that letter.
So both of these, and I don't know that I have a copy of the August letter here, but the July letter is dated, or is addressed 401A North 17th Street, 37206, as is the August 11th letter, which I just now have in front of me. So why did you not get both of those letters?
Well, I don't know. I didn't have a copy of that August letter until after this appeal was filed. I think Codes and Zoning is working really hard, but there's a lot going on there right now. I met with a zoning administrator in November of this year and was told that the permit was still active. And apparently the permit, at least in the system, in the Metro system, was still active, even though it had been canceled. So I don't know why they didn't receive the letters, but
okay.
But it is your testimony that they live in that home, they receive their mail at that home, they're there more than 180 days a year?
Well, more Mrs. McCool, because, so let me kind of give the situation of how they handle this property, because.
I have a question.
Yes,
Do you
ma'am.
know if the letters were mailed, certified mail, or just regular mail?
I
What
do
were you
not.
told about that?
Actually, let me spare Mr. McIntyre having a guess on that. On behalf of staff, they were not sent certified mail. I lick the envelopes myself, Ms. Sanford, drop them in the mailbox.
So I do not know beyond that. Ms. McCool and Mr. Asklin handle this property themselves. It is their personal residence. Mr. Asklin is in Phoenix most of the time, or more of the time. This is where, and I'll let Ms. McCool speak briefly to this also, but this is where she lives, her family. She was born and raised in Nashville, has been here all her life. This is where her 3 daughters and 4 grandchildren come to play. Apparently the neighborhood is much more peaceful and quiet when there's a tenant there when they're in Phoenix than when they're actually here in Nashville because of all the grandkids running around. Because this is their home, they vet every tenant. They contact each potential tenant when they are going to be in Phoenix, do not allow parties, do not allow pets, because it is their home and this is where their kids and grandkids stay. I'm not aware of the opposition today, but the couple here have several very close neighbors. As you can see in one of the images, there's another house 5 feet away from them, and they have an email. They've gotten 4 letters and emails from neighbors. One from Shay Spector that I believe was delivered to the BZA. I don't know if that's in your file or not, but I have those writing in support of the appellants, that there's never been a problem. They love having them here, and they support Mr. Asklin and Ms. McCool to continue to be able to use this as a short-term rental when they're away.
I don't see any letter like that in our packet.
I will provide those. One is an email from Shay Spector. One is an email from another neighbor, another immediate neighbor, Christina Rice. Another is a letter from Dan Reed and Kate Fikema on Ordway Place. And the fourth is a letter from Debbie Bridges also on Ordway. They're kind of on the corner of this street here, so if I may pass these in.
Is there any other questions that the board has or anything else that you'd like to add before we hear from the opposition?
Well, let me just allow Ms. McCool just briefly to testify about how the rentals have gone for them and kind of their process for allowing tenants into their home.
Oh, well, I don't think of our house as a rental house because, like you said, that's where my grandbabies come. That's where we do Christmas, birthdays, the whole thing. I'm very aware of there are some rental properties out there that's not maintaining their neighborhood and their house, and there's parties and all that stuff going on. That will not happen in my neighborhood. I'm not going to allow parties where my kids come and lay their head down, my grandbabies. I have 4 of them. I'm very respectful to my neighbors in my neighborhood. Born and raised, I'm a native from East Nashville. My parents, my kids, my grandkids go to East Nashville schools. So I just want you guys to know that this is not a party house. It's not something where we're in it to make all this money. It's just offsets us to be able to have our long-distance relationship until we build our business here, and for my grandkids to have a home to come and stay with me when I'm here. I'm here 2 weeks out of a month and 3 weeks sometimes, so it just depends. So it just helps us maintain what we're going on in our life right now. And I will apologize for anything that we haven't done correctly, and we're here to make everything's right. And, you know, like the gentleman said over there, there's a lot of parties going on in the neighborhoods, and it's not going to happen on our street. I check in with all of our neighbors every time we have a rental. A guest is like what I like to call people, not rental. But I call everyone ahead of time. If they inquire about our house, I want to know why they're coming to Nashville. I want to know who's coming with them. And that works out well. I've met a lot of great people doing that. And a lot of them are surprised that I'm not sending them an email and I'm picking the phone up and calling them, actually. So I appreciate you listening to us today. And like I said, I do apologize for anything that we've done wrong on our part.
So just to clarify what we're asking for, because at least to our knowledge, there has never been a complaint, neither from one of their guests or from a neighbor, who have all spoken in support, that at least the ones that we're aware of. But we have the time in March when they took things down, and then going all the way back to approximately August. You know, there's been 6 to 7 months already that they have taken this down. So they have, you know, made an effort to stay in compliance, to do the right thing. What we're asking for is, because of that time that's taken, we're asking for the board to reinstate the permit, effective, I think today would be a reasonable time, or tomorrow, but to go ahead and reinstate that permit. And we greatly appreciate the board's time, and we're glad to answer any other questions.
Any other questions at this time?
I have questions for the applicants. It's my understanding that your lawyer has indicated you did not receive a July 27th letter from Metro.
I get all the mail that comes to our house, and I've never received anything like that. So, which our houses are A, B, and C on our property, so a lot of times our mail does get confused, but no one has brought any letter or anything. I've not seen any of that type of letter.
And when you travel to Phoenix, are you stopping your mail?
No, ma'am. My daughter goes by, which lives like 5 blocks from me, and checks my mail.
All right, and you also, I understand from your counsel, you did not receive a letter dated August indicating that the permit had been canceled.
No, ma'am.
And I would also point out that August is about the time they got served with the second citation and went ahead and took it down then.
And I want to clarify the timeline as well, based on the file that I'm looking at. On March 10th, there was a stop work order notice placed on your residence, and rentals were taken down at that time. Is that right? And then I've got an email from Mr. Osborne to Mr. Askland on March 13th that he sent you saying with the short-term rental ordinance. Did you receive that?
To be perfectly honest, I don't remember an email, but I remember Robert and I actually had several conversations. When I got the notice of the stop work order, I didn't know what to do. I didn't know what that meant. So I immediately picked up the phone, spoke to Robert, said, can you please tell me what I'm supposed to do?
Yes, sir. And then he sent you an email that has the short-term rental ordinance attached to it, it appears.
Okay.
And said, if you're going to try to get permitted, this is what you need to understand.
Sure, from that conversation, actually, I remember the conversation that I took it down, and then we.
And then you obtained this permit dated April 18th of 2017, is that right?
Yes, ma'am.
The permit you've provided.
Yes.
And from that time, the home was rented, or it was open for rental, until you got the what, counsel? What stopped the rentals?
When they got served with that citation, the second citation, the first one, it was actually, I guess it was the same citation. It had a different citation number, but it was the same pre-March 2017 violation. But they actually received a second citation that Mr. Osborne had created.
What was the issue with the first? It was not served?
It was never served.
And why was it not served?
That's not a question I can answer. I don't know.
Okay.
We actually didn't know until Matt got served at his office in Phoenix.
Yeah, I had certified
We
mail
had no
sent to my
idea.
office in Chandler, Arizona, just outside of Phoenix, saying I saw another citation, and I again called Robert, but it took us probably 3 to 4 weeks to connect, and then I was told that I had to go to court, and
And then y'all appeared in court.
that's when I hired Matt.
And the agreement with Metro was that environmental case would be continued pending a ruling or a finding by this board.
Correct.
Correct.
And has the home been rented since that time?
I'm sorry.
Has the home been rented since the service of the Metro citation?
So like the cases before, we took it down. We had 2 reservations that were, when we had our permit, that I honored. I did not cancel those reservations.
Under the permit.
Yeah, when we got the reservations, it was, and if you guys understand how VRBO and Airbnb work, when the reservation is served, the person who's making the reservation is automatically charged. So it was,
No, I do not feel bad.
Okay, I know, I'm not trying to say you feel bad. No, I'm just saying. Okay.
I'm sympathetic to you, but
Okay.
you know, those are problems with those platforms.
I understand.
Here.
Right, I understand. So I did honor those 2 that were already paid.
Okay.
But they were started while they still had a permit.
Correct.
So it wasn't the case where they were operating without a permit at that
I
time.
had the permit at the
I
time.
understand. They were listed at a time they believed that were that this April
We haven't had a permit.
as far as they knew, was in effect.
Correct.
Okay. But they were allowed to go forward after they were served with a citation from Metro saying you do not have the authority to operate.
Well, we never.
It's okay to say yes.
Well, I know, and I guess just, I'm not sure, nothing was ever adjudicated in court. We didn't actually appear before the judge. We had our discussions with Metro Legal prior to it, and so we just announced, actually Metro Legal just announced a continuance, and it's been continued again just to be after whatever happens here.
Okay.
So.
Any other questions at this point?
Yeah, and God, I hope this doesn't confuse things anymore. Maybe that's not possible, but so.
Doing a fine job of that myself, I'm sure.
So what we've got here are citations and stop work, right? And so I guess you received both citations and stop orders at some point.
Well, so the stop work order came in March of 2017.
Right.
And that's when Mr. Asklund contacted Mr. Osborne.
And this is what triggered the citations later.
My understanding from Metro Legal is it's the same citation, and it's based on the same date of violation.
Okay.
So it's not 2 citations, it's 2 tickets.
Okay, I get that.
Okay.
I just want to be clear. Are we talking about 2 different orders or pieces of paper, or legal paper? I don't mean physical pieces of paper. Is there a citation in question and a stop order?
Yeah.
So does the
Mr. Osborne is shaking his head.
Okay, and so maybe my question is for Mr. Osborne: Does the citation? I don't want to get in the weeds here, but does the citation do the same as the stop order? Does it tell you to cease, or is it just saying you have to appear at court?
They don't say exactly the same thing, but they're related. So the stop work order is just to make sure that somebody knows right then that we are paying attention, that they don't have a permit to stop. The citation tells them when the court date is, or the warrant.
So, okay.
The citation accuses them of an offense, but it doesn't necessarily say you're
Right.
You're guilty, but you're accused of an offense, you need to come to court, but it doesn't say you have to stop like the stop work order does.
Right, there's limited room on the citation for us to fill in.
Okay.
But either way, they did stop.
Right, and that's what I wanted to be clear on. I don't think I've heard a case yet where we've had both to deal with, and I just wanted to make sure that we weren't overlapping
Robert,
terms or conflating.
I'm sorry, David, since you're here, do you want, I'm sorry, did you have something?
No, not for Mr. Osborne.
Okay, did you?
I had a question before we close the public hearing, I had a question for John.
We have opposition too to come up, so I think, so, yeah, how about you tell us how your experience syncs with what you've heard from the appellant?
All right, so back in March of 2017, on the 10th, posted the stop work order. That following Monday, I got a call from Mr. Asklund asking me some questions. I gave him a brief rundown, sent him the copy of the ordinance, said, hey, look into this, and if you want to apply for a permit, you'll need to come down and talk to zoning. As was our position at that time, anytime we found somebody operating without a permit, we went straight to a warrant or a citation. In this case, it took several attempts to finally get service. I sent warrants to the 401A North 17th Street, didn't get service on that. I sent it to the address listed on the property assessor, which is 2775 East Taurus Place in Chandler, Arizona, didn't get service on that. Sent a citation to 401A North 17th Street, which was returned, that was sent certified mail, and finally got service at his office in Chandler, Arizona.
When you're servicing these, are these all by certified mail, or are some of these in person or through an agent?
The citations are sent through certified mail. The warrants are served by the sheriff.
So has, if you've answered this question, I'm sorry. So was anybody actually knocking at the door, or are these all sent via the mail?
I believe somebody's knocking at the door with it. I would expect the sheriff to do that.
Okay.
And when you say you did not get service, that means no one responded, no one was home to get it?
Nobody signed for it. Nobody picked it up. It came back to us.
Okay. And the reason that it was going to go to environmental court was only because they operated without a permit?
Right. So on 3/10, I posted a stop work order, went back to the office, wrote the warrant, sent it out with a April, I think it's 19th court date. On April 17th, I got the docket, noticed that it was not on the docket, immediately notified the people downstairs to lock the parcel so that they could not get issued their permit because they were in the later stages of it, and all they had to do left was pay. That lock was not placed until the 19th. They picked up their permit on the 18th. So now we had to kind of go back and do all this.
So
yeah, that's okay.
So
it seems,
once, I'm sorry.
That's okay.
I'm so sorry.
It seems that not all of these STR cases go to environmental court, so why did this particular one go?
From about March till August, everybody that we found operating without a permit went straight to court.
Okay, I see.
Typically, if Metro finds through host compliance or by complaint, if we determine that someone has operated or advertised without a permit, we will take them to environmental court. If they self-report, or if we send them a letter, and now we'll send them a letter and give them an opportunity to come into compliance. If they then come and try to come into compliance, they can come to the BZA. But environmental court, correct. But that's the BZA is typically people who are who learn one way or another that they have to have a permit and then come in and try to obtain that permit. And if we determine that they are operating and they have not done anything to try to obtain a permit and don't do anything to try to obtain a permit, then it will go to environmental court.
And, okay, it's all a little confusing, but you said something between May to August, you were sending them to environmental court. So after August, they don't automatically go to environmental court from a host compliance complaint?
Correct. Once we entered into a contract with host compliance, we now send out letters giving them, and it's really a courtesy. We're not required to give them a chance to come into compliance, but we give them a courtesy opportunity to come into compliance. If they then come into compliance and on their own and are trying to get a permit, then they can come to the BZA.
Which explains all of our host compliant related cases that are new rather than, before they were just going to environmental court and they were getting a. Did you have anything else to add or anything else that you heard that you needed or wanted to respond to?
I think that's it.
All right, thank you. Any other questions for the applicant at this time? If not, then you have 1 minute and 48 seconds for rebuttal, and we'll hear from the opposition. All right, opposition, if you'd come up and state your name and address and tell us what you'd like to say.
Good afternoon, ladies and gentlemen. My name is Joel Reist. I live at 408 Avondale Drive, Nashville, Tennessee, 37206. I'd just like to point out that the clock was stopped at 1 minute 48 seconds for quite a long time.
Well, in any time that we're asking questions, the clock doesn't run.
Okay, thank you.
So, and it will be the same for you.
Gotcha, thanks. I have to admit that this is pretty confusing. I initially was interested in coming down here to observe what was going on because I've lived a stone's throw from 401 South 17th for about 20 years now. I'm just a little concerned that these folks don't live there more than 180 days a year. In fact, the board asked that question, but it was not answered. If they don't live there, I'm just concerned that dedicating another entire single-family home as a short-term rental property takes away a housing opportunity for a person or family who could be a neighbor in our neighborhood. And we would lose a chance for neighborhood kids to go to Laughlin Design Center, which is an elementary school in whose priority zone that this house is located. Gone would be a potential friend next door who could look after things when others are out of town. Gone would be a neighbor who, in return for a ride to the airport, could walk another neighbor's dog. Gone would be a potential neighbor who could help an elderly friend bring groceries in from the car. And if this sounds fanciful, I've been on both sides of those kind of situations, except I haven't been elderly yet. In return for this diminishing quality of life and erosion of the fabric of our neighborhood, we would instead receive a revolving cast of bachelorettes and other transients. Now, this would all be to make easy money for somebody, maybe somebody who lives in this house less than 6 months a year. I don't know. But I do know that we need neighbors, and people who are investors are not neighbors, and an endless stream of well-intentioned tourists is not a community. And the detail that really diminishes any of the ambivalence I have had about this case, although I have to admit I was really confused by the presentation, so I may be wrong. If they operated a short-term rental property without, obtaining the legally required permit, that should be enough reason to deny the appeal. And furthermore, and lastly, I'll conclude by just noting, living near this corner for quite a long time, that originally it was one house that was purchased, raised, and then 3 houses were crammed into that lot. So I'm just turning one of those houses into an STRP adds insult to injury for me as someone who's invested in the community. Thank you.
Are there any questions? Yeah,
I will clarify that this might be, I guess, couched bad news, but as far as residency goes, we're not actually, and I'm looking at council as I'm saying this, we're not actually tasked with determining residency, and I would think, unless that is at issue. If the denial of the permit were because it is the administrator or the codes has deemed it not to be a primary residence, then we would be hearing debate on that and finding that. But To my knowledge, we are not finding that or being asked to find that in this case, are we?
That's correct. The definition of owner-occupied simply says that the permittee must permanently reside there. It doesn't give any, and then they have to prove residence through a number of documents that they can provide. So yes, if the zoning administrator denied a permit based on residency and that were appealed, I think you would determine whether or not they're a permanent resident. But otherwise, the definition of owner-occupied simply says they shall permanently reside in the home.
Well, and I just 2 cents on that. I'm very empathetic with the neighbor on that point, and also frustrated that. And this isn't the case we're hearing. The case we're hearing is strictly about they operated and that piece of it. If there's evidence that they don't live there, then that's something that can be challenged. It's opposed to an environment. Where does that get challenged? And again, not necessarily in this case generically, how would one make a complaint to codes or to?
And presumably, if Metro learned that someone fraudulently represented that they permanently reside somewhere when in fact they don't, we would take that up in court, probably environmental court, for operating without a valid permit.
But just as a comment for the neighbor, we have had those cases before, and the rule is, again, not that we wrote, that was passed by the Metro Council, does talk about permanent residency, and it gives documents that you can provide, a driver's license, mail, that type of thing. And there have been cases that had a lot of folks that came and said we don't think they lived there, but they had everything that the law required. And so I think that it's a very difficult thing, and would urge folks to talk to their council members about that if that's a concern. But I have absolute empathy with that concern.
I think anyone could be excused for being confused about this particular case in general.
So you have 1 minute and 48 seconds to wrap up and rebut anything that you'd like to rebut.
And primarily on, rebuttal is meant to be focused on items brought up by opposition. And to my knowledge, if anyone else remembers anything, but it seems like residency was the only thing that primarily was asked.
Well, the one thing that Robert did mention, Mr. Osborne mentioned, was that there were lots of attempts to, hunt the applicants down by certified mail and by warrant, and you all are hard to find. Why is that?
For one of the addresses was wrong that he'd stated.
Okay, now that, and that is, one of the issues here is the toughness of communicating. The not getting mail and that type
I
of
would
thing.
like to comment on that. I have often had my mail misdelivered. That's why I was concerned as to whether it was certified mail or not. The street over from me has a house with my same house number. My mail often goes there. Theirs comes to me. I make an effort to get theirs to them. They don't give me that courtesy.
To the same point, the gentleman mentioned that they took down one house, put up 3. There's 3. It's 401A, 401B, 401C. We get their mail all the time.
And also, I went to Laughlin Elementary, and my grandkids go to East Nashville Elementary.
Yeah, ma'am, if you can address.
I'm sorry, I just wanted him to know, my heritage is East Nashville. Born and raised, my grandmother, my parents, I am East Nashville. I just want him to know, my grandkids are going to East Nashville schools.
I agree with what he said.
We are a family.
I agree with what he said.
I do too. I don't want to see our neighborhood go away and not be family oriented at all. So, I just want him to know, I'm born and raised 2 blocks from the house I live in now.
Right, okay, sir.
And I can provide Ms. McCool's driver's license. I would ask if we do provide it that the number be redacted.
No, again, this is not about, the case we're hearing isn't about residency. If that is an issue that's of concern, that it can
but they did not,
as it should play.
They did not build this house, whether they're too crammed in. That kind of happened before they had anything to do with it. But if there's concern about the type of neighbors that these folks are, I would encourage you to read the 4 letters from their immediate neighbors, how they interact with their children, Halloween parties, walking the streets together. These are good neighbors who are devoted to this neighborhood. They've done what they can to be compliant. They went through the process to get a permit, and they have been suspended from that for, going on 6 or 7 months. And so we would just renew our request that their permit, this board use its discretion to reinstate that permit as of today. And thank you for your time and consideration.
Any other questions? Then we will close the public hearing. What are the thoughts of the board?
I have a question, I think for John Michael, or whoever he directs me this is for. So in this case, we are looking at a permit that issued on April 18th. If I understood Mr. Osborne correctly, it was 24 hours before he tried to put a lock on it. Otherwise, they would have been denied the permit and given an opportunity to come here at that time. Is that right?
That's exactly right.
The violation would have been operating without a permit.
That's right.
Okay, and they would have not issued the new one and sent them here back in April, likely. April 19th if they'd been down here. But then it was 90 days before the next notice to them happened. Is there any reason why we would think they should have known they shouldn't have had that permit before that first letter? I know they dispute that they received it, but you've testified you mailed it, and
I would contend there's no reason from the date of issuance of the permit in April to the date of the sending of the letters, and I won't try to speak to mailing confusion,
Right.
but no, there's no reason in April, May, June, most of July, they had a properly issued permit in hand, issued in error by the Metropolitan Government, but on the permittee side, they're doing nothing wrong. They've got a permit in hand that they think they've done correctly, and they're operating clean during that period.
okay, thank you.
Any other?
Okay, I'll keep talking. If anybody else?
I was just going to make one of my false predictions again about what we should do, but
Go ahead.
I mean, I kind of feel like this hearing is punishment enough for us, but I feel like these are extenuating circumstances and bizarre. And I haven't heard anything that, I mean, there's odd things, but I don't think anyone has been avoiding, or I've seen no evidence anyone is lying about receiving anything. And I get the mail thing, I get the wrong 619 all the time.
Okay.
So, I hate to predict it because this won't go well for you if I predict it, but I kind of see this as a time served kind of issue.
Well, and even I think if you had, if you were comparing to other cases to say, well, they booked some while they had a permit, they got cited, and I think there's even some there. I mean, it's been more than 4 months since they've rented, and so time served is substantial, and more if you count that window.
The time served is more than most people that we give 4 months to.
Is that a motion that you'd like to make?
Yeah,
Mr. Vice Chairman, please forgive me, just so that we're clear, and whatever motion you're going to make is going to be fine. It is an appeal of a cancellation, not a denial. So if it is determined that the zoning staff erred in canceling in this unique circumstance, that would effectuate basically the renewal of the permit tomorrow as soon as we can get in the morning and green light it again, to be clear on the effect of what the vote would be. So if on the other hand you determine that no, the zoning administrator did not err, but some other decision, you have the right to make that motion. But for the benefit of our record and the clarity of the final order, we'll probably need to make that clear in our motion.
I will move that we find that the zoning administrator did err, albeit unintentionally, and that the permit be reinstated.
I second that.
So can you get to the same answer with saying the zoning administrator did not err?
Do you mean that he erred in canceling the permit?
What did I say?
You just said that he erred.
You said he erred in canceling the permit, but the permit was issued in error, so, I mean, we're discussing the motion that's been seconded, but it seems like the zoning administrator didn't err in canceling the permit, but
They should be allowed, but did the permit
should be.
They should be allowed.
I don't think that we could
Just reinstated?
So the issue before the board today is that the permit was canceled by the zoning administrator because the permit was issued in error. They have appealed that cancellation, saying it shouldn't have been canceled.
Yeah,
So the issue is, if you determine that he erred in canceling the permit, then the permit will be reinstated.
Yeah,
If you
and
determine
it
that
is-
he did not err in canceling the permit because it had not been issued in error, the cancellation will stand.
Yes, and I am indeed saying that it was an error to cancel the permit.
And I am indeed seconding that
All right,
motion.
we have a clarification. Thank you. We have a motion, we have a second. Any more discussion? All in favor, say aye and raise your hand. Aye. Any opposed? That passes 6-0. Yeah, and let's take a 5-minute recess and convene.
We'll reconvene with case
5 minutes.
392 after the break.
Mr. Vice Chairman, we'll reconvene with case 2017-392.